Hello there, I'm Kelly Longtin from Kelly Longtin Law, and welcome to our YouTube channel. Today I want to talk to you about incapacity, planning, and pets. Few U.S. adults actually have an estate plan, and even fewer have included their pet in their plan. Perhaps you have an estate plan that addresses who will take your pet when you die, but does it address the possibility of your incapacity and the need for a temporary pet caretaker? Formally incorporating your pet into an estate plan can ensure that no matter what happens to you, your animal companion will be cared for like any other family member. Now, we all know that Americans love their pets. The U.S. pet ownership rate is among the highest in the world, and it has grown over the past few decades. However, calling them pets, where they're generally considered property under the law, does not do justice to how much we value our furry, feathered, or scaly best friends. A 2023 Gallup poll showed that 62% of Americans own a pet, and more than one-third have multiple pets. I'm one of those. 97% of pet owners say that their pets are part of their family, including 51% who say they're as much a part of their family as any human member, which is true in my household too. Pet spending per household has also increased and is now around $600 to $800 a year. In keeping with the changing cultural mindset that pets are members of the family, owners are spending money on toys and treats and clothing and travel, daycare, pet sitting and boarding services, pet-specific insurance policies, and premium healthy pet food. Spending more on pets reflects owners' recognition that animals have complex physical and emotional needs that are not very different from our own. The law is also slowly starting to catch up with the idea that animals are living, feeling beings who deserve legal protection. While U.S. law has historically classified animals as chattel or property, this began to change in the 1800s with the introduction of animal cruelty statutes. Today, animal rights have advanced to the point where some states consider a pet's well-being or best interest after their owner's divorce. Estate planning is another area in which legal decision-making increasingly reflects the deep and meaningful bonds that we share with our pets. Every state now recognizes pet trusts, and more people are including pets in their estate plans to ensure their beloved companions are provided for if they die or suffer an incapacity. The pandemic was a wake-up call for many to get their estate plans in order. COVID also showed that when a pet owner gets sick and can no longer care for their animal companion, the pet could end up in a shelter. Of the approximately 6.3 million pets entering U.S. animal shelters each year, nearly 1 million of those are euthanized. Now, not having an estate plan can leave big questions unanswered, such as who will care for a minor child after a parent's death or a health emergency. Without an estate plan, the same question applies to all of your pets. And this does not mean that pet owners should go to extremes like Leona Helmsley did when she left $12 million in her will for her dog. However, there are good reasons why pet parents should formally include pets in their estate plan and not rely solely on an informal verbal agreement with a caretaker. You as a pet owner should also plan for your pet's caregiving. You'll want to arrange for multiple caretakers, decide whether multiple pets should stay together or be placed with different caretakers when you're developing this plan. Talk to potential caretakers about their pet's needs, provide them with feeding and care instruction and veterinarian contact information, and give them a key to the house. You also want to let friends and family know who the available caretakers are and how do you go about getting in touch with them. Best Friends Association also recommends incorporating emergency and long-term pet care in a formal estate plan, such as a will or a trust. Because pets are viewed as property under the law, they become part of a person's estate when they pass away. As a result, a pet owner can leave their pet as a gift to someone else, the same way that they could leave any other property. The beneficiary of the pet would be known as a pet guardian. However, there are shortcomings to planning for a pet's care in a will. First, the person named as pet guardian could decline the gift of the pet, as there is no legal requirement for a beneficiary to accept any gift from a will. Your will can provide for a backup pet guardian or even multiple levels of backup pet guardians. But what happens if all of them decline the gift? You may think it would be a good idea to name an animal welfare organization as a beneficiary as a backstop, but Best Friends cautions that these organizations typically cannot offer the type of long-term care that a pet needs. So what happens if everyone that you named as a pet guardian declines or cannot care for your pet? Second, a will only takes place upon death. Its terms do not apply when the pet owner is alive but incapacitated and can no longer care for the pet. Therefore, the pet could be left in legal limbo if the owner is sick, comatose, disabled, or otherwise unable to care for their pet. A pet trust allows an owner to exert more control over their pet's future care, both after the owner dies and during their lifetime if incapacitated. All 50 states and the District of Columbia have a pet trust law. These laws vary somewhat, but in general, they allow a pet owner to create a trust and place money in the trust for the benefit of their pets, payable to a named caretaker under the oversight and at the discretion of a third-party trustee. Depending on state law and the type of pet trust, the trust instructions can name a specific caretaker and provide authority to the trustee to find an alternative caretaker if the original cannot or will not take possession of the pet. Most states allow pet trusts to be established during the pet owner's lifetime, so the terms of the trust would apply even when the pet owner is alive but incapacitated. These provisions can be highly detailed, specifying how the pet should be cared for, including feeding, housing, veterinary care, and burial or cremation. Pet trusts can be designed to benefit multiple pets, including different species of animals and sometimes the offspring of those pets. This should be considered when deciding how much to allocate to a pet trust, as certain types of pets require more substantial funds to cover their care and needs. The owner can even state in the trust document that any money remaining after their and their pet's death goes to a nonprofit animal rescue organization or any other beneficiary, human or otherwise, of their choice. They can further state how and how often trust money should be distributed to the caretaker for the pet's care or even for the compensation of the caretaker. Pet owners can be as meticulous as they want in their trust instructions. They can also allow the trustee and caretaker some discretion to decide what is best for that pet. The trust should be funded with sufficient resources to care for the pet adequately over their expected lifespan. Pet owners can also use a power of attorney to plan for pet care during their incapacity. Power of attorney is a document that gives one person the legal authority to decide for someone else. Depending on state law, the document can be limited or broad in scope. It can also be ongoing, effective until the document creator dies or revokes it, or only effective for a defined period. A power of attorney for the care of a pet should include language that authorizes a named individual to make pet care decisions on the owner's behalf. It could provide broad authority, stating that the pet caretaker is allowed to do whatever they think is reasonable, or it could limit their authority to specific actions. A power of attorney can address pet issues like care services and finding a new home for the pet if the owner remains incapacitated for a long period or has to move out of their home. Pet incapacity planning is often overlooked. Your animal companions have a special place in your heart, but do they currently have a place in your estate plan? Even the most detailed and well thought out estate plans may fail to include pet care and incapacity provisions. If you have questions about your pets and estate planning, or you need to update your estate plan to cover your new pet, you want to get in touch with your qualified estate planning attorney that practices in the state in which you reside. I want to thank you for watching. Please like and subscribe our page to learn about all things estate planning. I'm attorney Kelly Longtin from Kelly Longtin Law.